Please be seated. We have the quorum, we can start. The next person is Honourable Levy.
Yes. Thank you, Madam Speaker, for giving me the opportunity to say a few words on this very important amendment bill. First of all, let me seize this opportunity to congratulate Madam Speaker.
Thank you.
For being elected as Madam Speaker and the Deputy Speaker. So we have restored some dignity and decorum in this temple of democracy. And talking about democracy, the Honourable Attorney General has very vividly portrayed what is the vision of this government, restoring democracy. And this is a stepping stone. This is the correction of the derive of the previous regime with regard to systematically attacking our democracy. Our basic principles of separation of powers has always been hampered by this previous government. And restoring the prosecutorial powers of the Director of Public Prosecutions goes in line with what we have promised to the people of Mauritius and with what we have been voted to come here and represent the people of Mauritius overwhelmingly. And, Madam Speaker, if I may, the advent of the Financial Crimes Commission Act, when we were in the opposition during the last mandate, we vociferously condemned this bill. We vociferously voiced out our concern as to the way things were going. And surprisingly, the former government would pay no heed to what we were saying. It was just like So, Madam Speaker, when we were elected overwhelmingly to represent the people of Mauritius, the first and foremost function was to restore the dignity within the ambit of separation of powers. The executive has got its role, the judiciary has got its role, the parliament has got its role. And the Director of Public Prosecution, as clearly pointed out by the Honourable Attorney General, has got very important constitutional roles. And this, Madam Speaker, goes in line, if I may quote, in the government programme at page 2. Under the very important caption of democracy, governance, integrity, and constitutional reform. Paragraph 6, fourth line. Government is committed to restoring the trust of the nation in independent and impartial institutions. So this very first amendment to this very infamous Financial Crimes Commission Act is the first step to restore the powers of the DPP that has been curtailed several times by the previous government. And when I was listening to the Honourable Leader of the Opposition, I'm not surprised at all as to the argumentative with regard to their views with regard to the powers of the DPP. Because we know, way back in 2015, how the previous government, the MSM-led government, the l'Alliance Lépée government, wanted to create history in the wrong way by introducing the Public Prosecution Bill and amending the Constitution to curtail the powers of the DPP. This is in the DNA of the MSM. But I'm very surprised and astonished that the PMSD in 2024 swallowed their pride that, you know, we were so happy of getting out of government to preserve democracy, and yet they sat with the MSM. Xavier-Luc Duval, in his speech during the Financial Crimes Commission Bill, he condemned the way the powers of the Director of Public Prosecutions was being curtailed. Yet, the PMSD went along, condoned this act of treason against our democracy, against the people of Mauritius. Fortunately, the people of Mauritius has sent us here and has sent these two gentlemen there. Madam Speaker, this first stepping stone is now another stepping stone for the Honourable Attorney General to come forward with a comprehensive legislation, a robust, a transparent legislation that would really combat fraud and corruption and financial crimes in this country. And here again, Madam Speaker, I shall refer to page 5 of the government programme, whereby at paragraph 10, it is clearly stated, the Honourable Leader of the Opposition was saying that, we need to have legislation that will fight fraud and corruption. But here it is, I quote, "Government will repeal the Financial Crimes Commission, FCC Act, and will set up a national crime agency which will better equipped to deal more effectively with financial and other serious crimes." So it is clearly stated in the government programme. The first step, first and foremost, is to act promptly, to stop the rot that is being caused with regard to our penal system, to restore the dignity, to give the Director of Public Prosecutions its own right to act in his role as per the provisions of the Constitution. And the second step is to repeal this infamous Financial Crimes Commission Act and have a comprehensive legislation that will set up this National Crime Agency. So I welcome this bill, we support this bill, and I'm sure that the nation at large today is breathing with a sense of relief that at least we are preserving a very important institution, that is the Director of Public Prosecutions. And all those cases that we have in court will remind the DNA of the MSM to curtail the office of the Director of Public Prosecution. Way back in 2015, after trying through the back door to come with this public prosecution bill, they removed the administrative control in the hands of Director of the Public Prosecution and revert back to Attorney General's office. And this case is still before the Supreme Court. The DPP lodged a case in the Supreme Court, and we are still awaiting this case to be heard. Just to tell you how the image of the country took a backseat with the MSM-led government trying to curtail the powers of the DPP. Those are things of the past. We are looking towards the future so that let Mauritius be Mauritius again. Thank you, Madam Speaker.
Honourable Minister.
Madam Speaker, the object of the bill, as stated in the explanatory memorandum, is to restore the prosecutorial powers of the DPP under the Financial Crime Commission Act. Let us remind the House again what Section 72, subsection 6 of the Constitution reads. In the exercise of the powers conferred upon him by this section, the Director of Public Prosecution shall not be subject to the direction or control of any other person or authority. And yet, as has just been highlighted by my learned friend Honourable Lobin, the MSM has systematically tried to control the DPP in the exercise of its constitutional powers. And the enactment of the Financial Crimes Commission in 2023 is one but the loss of a long series of attempts to curtail the powers of the DPP. Honourable Lobin mentioned that right after coming into power in 2015, the first legislation that was passed, the Financial Amendment Bill, was to take the DPP, the independence, the financial and administrative independence of the DPP and put it under the aegis of the Attorney General. And since then, each time the DPP had to travel, or an officer of the DPP's office had to travel, they had to ask permission to the Attorney General. And very often, this permission was denied. So that was one means of putting pressure on the DPP. Another means was the Prosecution Commission, which at that point, the PMSD decided not to support because this was anti-constitutional. But there was more. There's more, Madam Speaker. Back in 2015, let us remember that was the time of terror, one of the darkest times of the democracy of Mauritius, one of the darkest days of democracy, where people were being handcuffed, humiliated, brought before court with unsubstantiated provisional charges. And among the long list of people who suffered this political vendetta, there was also an attempt, let us not forget, an attempt to arrest the deputy, the Director of Public Prosecution. One early morning, he had to sneak out from the back door and seek legal protection from the judiciary under what was a blatant case of abusive arrest. So, Madam Speaker, what happened in 2023, the attempt by the government to curtail the powers of the DPP was not innocent. It was a deliberate and calculated policy to curtail the role of the DPP. And, as rightly pointed out by the Attorney General, the Director of Public Prosecution decided to seize the Supreme Court for constitutional redress. And what is the Director of Prosecution asking the Supreme Court to state? The DPP humbly prays from the Supreme Court for a declaration pursuant to Section 83(1) and 83(2) of the Constitution that the Financial Crimes Commission Act 2023 contravenes Section 1 and Section 72 of the Constitution and is accordingly void. This is exactly what when we were in the opposition, we stated when the bill was voted, when the bill was debated. We stated unequivocally what was going to happen, what was happening was against the Constitution. And today, with this bill, Madam Speaker, we are correcting a wrong. We are giving back the power of the DPP. We're restoring his constitutional powers. And we are doing it in three ways. There are three sets of amendments which is being brought by this bill. The first one is restoring the power of the DPP to institute prosecution in financial crimes. Under the existing legislation, once the Commission has completed its inquiry, it can decide, without having to go through the DPP's office, it can decide to institute prosecution. Now, this can be subject of abuse when we know that the Financial Crimes Commission is manned by political nominees, handpicked by the Prime Minister, whose terms and conditions are known only to the Prime Minister. So it's very easy to see the risk of the Prime Minister dictating to the Financial Crime Commission to initiate criminal prosecution for financial crimes against opponents of the then government. But now, with this amendment, the Financial Crimes Commission, when they complete their investigation, they are duty-bound to send the file to the DPP, and it is the DPP who will institute prosecution or the DPP who will authorize the Financial Crime Commission to institute criminal proceedings. So this is the first amendment that we are bringing. The second amendment, which for me is more fundamental and more important than the first one, it relates to the constitutional power of the DPP not to prosecute, to discontinue prosecution. Now, before we had the Financial Crimes Commission Act, we used to have the Prevention of Corruption Act. Under the Prevention of Corruption Act, ICAC, the Independent Commission Against Corruption, had to investigate a criminal crime, and then they decide, after gathering all the information, they send the report, they write a report, and send everything to the DPP's office with a recommendation. The recommendation can be we prosecute or we discontinue investigation, we close the file. But they were under the legal obligation to refer the file to the Director of Public Prosecution. They could not close an inquiry without informing the DPP, because the DPP may very well not be in the same wavelength as the FCC. Even if the FCC thinks that there is not sufficient evidence to bring prosecution, the DPP could have thought otherwise. And this is why, Madam Speaker, ICAC never sent to the DPP files relating to Angus Road, to Bet 365, to l'affaire Saint-Louis, to Stag Party, because they knew that they could not close the file without the consent of DPP, including Alvaro Sobrino. So in 2023, what they do? They amend the law to allow the Financial Crime Commission to terminate inquiry, to set aside the file, close the file, in the back behind the DPP. And there is no legal obligation for them to send the file to the DPP. So the DPP is not in a position to know whether there is a case, what is the status of the case, whether there is sufficient evidence to prosecute or not. But now we're changing it. With this amendment, the Financial Crime Commission is duty-bound. When they finish their investigation, they have to transfer the file to the DPP. And the DPP will decide. The DPP can decide that, okay, prosecute, or, okay, go back and investigate further, or the DPP can say, we discontinue. I say this is the most important aspect of the bill, Madam Speaker, because the power that was given to the ICAC was essentially a power that was given to the Financial Crime Commission, was the power to cover up, was a power to cover up all the mistakes, all the fraudulent activities of those close to power. Donc c'était une institution pour blanchir les criminels, les corrompus. The third set of amendments, Madam Speaker, relates to compounding of offense. Now, what is compounding of offense? You're caught red-handed, you have given a bribe, or you have taken a bribe, or you've used your influence unduly for gratification, you've acted corruptly, or you have mismanaged funds, dilapidé les fonds publics. So you're caught red-handed and you have to be prosecuted. Today, as the law stands, the Financial Crime Commission can call you and say, you've been a naughty boy, you've been bad. So no, you know what? I'll give you a fine. Pay me 10,000 rupees, case closed. And once I have compounded your offense, no one can prosecute you for what you have done. No one, however big the crime, however much you have stolen, however big the corruption offense, the Financial Crime Commission was given the power to compound, and once they have compounded an offense, no one, not even the DPP, could have prosecuted that person for that offense. Now, how can that be in a constitution, in a democracy, that people can get away with it when we know that the FSC is manned by politically appointed people? So what we're doing today, Madam Speaker, is amending the law so that before the Financial Crime Commission can compound any offense, they have to refer the file and get the consent of the DPP. So this is a safeguard. The DPP, obviously, They may agree with the compounding or they may not agree with the compounding, but the power is restored back to the DPP. And it is the same in many other legislation. For example, in the Customs Act, you have the possibility to enter into an agreement with the MRA, you pay the penalty, and the offense is compounded. But it is subject to the consent of the DPP. So as the law states, we did not have this safeguard. So what we're proposing to do now with this amendment is to get the consent of the DPP before the Financial Crime Commission can compound any offense. The Honourable Leader of the Opposition stated that, we're only amending a few provisions of the law, which means that we agree with the remaining provisions of the law, and therefore we agree that the other provisions of the law is good law. No, Madam Speaker. No. We have pledged in an electoral manifesto, in the presidential address a fortnight ago, that we are going to repeal the whole of the Financial Crime Commission Act. We're going to replace the Financial Crime Commission with a new national crime agency, which will be totally independent, which will be robust, and which will have the means to do their work effectively and efficiently. But it will take time. It will take time after consultation to come up with this piece of law. So in the meantime, through this bill, we are addressing the most urgent and objectionable provisions of the Financial Crimes Commission, which is the power that was usurped from the Director of Public Prosecution, so that now when we do come with our National Crime Agency, Madam Speaker, there will never again be a covering machine. Thank you.
Yes, Honourable Member. Not Honourable Nottingham, please.
Madam Speaker, thank you to give me the floor. My intervention will be on the following points. First of all, I will comment briefly on the structure of the bill and its importance. And also, secondly, I will be commending the Attorney General. And thirdly, I will be speaking about the political motive behind the Financial Crimes Commission and how the law was ad hominem. And also, I will be commenting briefly on the violation of the Constitution and violation of democracy, and also commenting on violation of fundamental principles of justice and the criminal justice system, and referring to the independence, principle of fairness, and impartiality. And finally, the shortcomings of the Financial Crime Commission. Comme point préliminaire, Madame la Présidente, j'attendais beaucoup de l'intervention du leader de l'opposition. Comme vous savez, cette auguste assemblée est supposée maîtriser l'art de la dialectique. J'attendais beaucoup, et moi j'allais réfuter, et je pensais que le leader de l'opposition allait réfuter à l'honorable Attorney General. Je suis resté sur ma faim, mais donc ce sera pour la prochaine fois. So this bill, commenting on the structure of the bill, Madam the Speaker, the bill comes to cure a mess, and I would say a big mess, created by the previous regime. And I may qualify the FCC Act of 2023 as a vicious and insidious attack on democracy and our criminal justice system. Entrusting powers to the Director General of the FCC was potentially a breach of Section 72 of the Constitution, but also Section 1 and Section 10 of the Constitution. Madam the Speaker, we should not have a short memory. Let us not forget, as pointed out by my earlier speakers, that there was an attempt to undermine the powers of the DPP with the introduction of the Prosecution Commission Bill. And in 2023, the killer of democracy and human rights repeated the crime again. Il récidive, Madame la Présidente, as if it was not enough to be the serial killers of people like Mr. Kistan Kanaki and others. They are also serial killers of our democracy and the cardinal principles of our criminal justice system. The FCC Act of 2023, Madam Speaker, breaches Section 72, subsection 6, which reads as follows: in the exercise of the powers conferred upon him by this section, the Director of Prosecution or Public Prosecution shall not be subject to the direction and control of any person or authority. So indirectly, the DPP always have been having sole responsibility in matters of prosecution. Now, coming to my second point, commending the Attorney General. I must commend the Attorney General for the celerity with which he has come with such a bill. Today, in fact, with the caliber of the Attorney General, we are in safe hands, not in the hands of those who will neglect their job and enjoy stag parties. Let us remind the population that the actual Attorney General has left a lucrative practice to be at the service of the nation, and he has to be commended for that. Madam Speaker, I'm also impressed by the comprehensiveness of the bill and the quality of the drafting. I know you've got a team behind you, but at the same time, we can feel that it has got your touch. Thank you. And above all, when we read the amending bill, we can see the clarity and also the improvement which has been brought to the bill. For example, if I can cite a few examples, for example, the Commission now is made accountable to the DPP when an investigation is discontinued by virtue of Section 5 of the bill. The DPP may also, you will see, request the FCC to give reasons, and this is quite new, for discontinuing with an investigation. And compounding offences under the FCC Act or Declaration of Assets Act will also require the consent of the DPP. And donc, retournons à César ce qui appartient à César. More importantly, Madam the Speaker, the Director General of the FCC shall not prosecute except with the consent of the DPP. This is in line with the letters, not only the letters of the Constitution. More importantly, what we don't realize, the spirit of the Constitution. So it would seem that the previous regime, either they were not aware or they did it deliberately to forget the very spirit of the Mauritian Constitution. So, obviously, even in the past, the DPP could delegate and give consent for others to prosecute. Even the police could prosecute, but with delegation of powers. But nobody could usurp his powers. Now I come to a very, very important point. What I call, what was the political motive? The leader of the opposition was giving a number of reasons. But when you look at the substance of the bill at that time, which eventually became law, we did not see any curative measure to address the concerns of international organizations. So, at face value, the bill seemed to have noble intention and legitimate intention. However, let us not forget the obsession and the compulsion, what we call in the French medical jargon, a talk, which was being suffered by many of the politicians in the previous regime. You understand what is talk? To kill politically the actual Prime Minister when he was on the ground. The FCC bill came after the failure, just remember, of more than 12 concocted cases against the actual Prime Minister. In the same vein, the Good Governance and Public Integrity Bill, and which later became an act with its noble, probably intended objectives, was, however, primarily destined to kill politically the actual Honorable Prime Minister. So it was, and I would lay emphasis, a concerted plan and a plot to finish the main opponent, conducted by Judah, but also the master of Judah, and other accomplices like the Stag Party men who were involved. They strategized, they conspired, nothing less than one of the biggest, and I hammer on that, one of the biggest conspiracies in our political history, Madam Speaker. one Judah is under arrest for now, but I believe that the king of Judah is still scot-free. So you know how the actual prime minister saved him from la poubelle de l'histoire in the by-election that we had. My appeal, Madam Speaker, we should never, ever have ad hominem laws in our country. This was definitely a law, even if it will not please the leader of the opposition. This was a law destined to finish off one man who was haunting the mind of a dictator's dream. Sad for our beloved country. Now, coming to another point, very important point, where we saw a violation of the Constitution and democracy. And you will see, Madam the Speaker, one of the fundamental tenets of democracy, a legal concept, touched by many of my friends, a legal concept enshrined in our Constitution, which is not a mere rhetoric. This concept of separation of powers is not concrete in our Constitution, I concur, but it is underlying throughout multiple sections of the Constitution and consecrated by many eminent judges, like the father of the Attorney General, Justice Glover, Justice Rowe, Justice Lala, and so many others. Many tend to think that separation of powers is just a classical separation of powers as expounded by Montesquieu, as referred to by the Attorney General. But over time, many other jurists in US, in India, has further refined this concept of separation of powers. And this is where, in my own humble opinion, the DPP in trial law is not a pure member of the executive. According to me, in the course of our future revisiting of the Constitution, we have to think whether we should place the DPP under the heading of the executive, or we have to create another chapter where we have, for example, quasi-judicial bodies. This is food for thought, reflection for the upcoming amending of the Constitution. So, when we look at the purpose of DPP provided by Section 72 of the Constitution, you will understand, Madam Speaker, that this has been purposely entrenched and constitutionalized to make him independent and impartial. And here it is good, I think the Attorney General also mentioned that. And in fact, that quotation came from Professor Desmith himself, where he said, to safeguard the stream of criminal justice from being polluted by the noxious political contamination. In fact, the Law Reform Commission took on board the quotation coming from the horse's mouth, that is the Professor Desmith, the founding father of the Mauritian Constitution. That is what the previous regime did with the FCC. And shame for this abominable crime against our democracy and Constitution. The same was hammered, as mentioned rightly by the Attorney General, during the Lancaster House Conference. And as per Section 72, the role of the DPP is to prosecute, but also to oversee investigation. This is where, for example, in the case of Kisnen, where the DPP asked the police to make a complément d'enquête, and this is possible. And the police or the ICAC or the FCC is meant to investigate, not to prosecute. Never in the history of Mauritius has any politician sought to give such powers to the police, and they gave it to the FCC. So the segregation within the executive itself prevents any form of conflict of interest. And this is very important for the population to know. And the officer, you will see that the DPP and its officers are guided by stringent standards, international standards, as well as local standards, in order to guarantee fairness, independence, and impartiality. Besides the violation of the Constitution, you will see a number of fundamental principles of the criminal justice system have been violated. And I think at this stage it is important to understand the difference between the appointment of the DPP and the Director General of the FCC. And you will note that the DPP, very important point, is appointed by the Judicial and Legal Service Commission. Whereas the Director General of the FCC is appointed, yes, by the President, but, very important point to note, upon the advice of the Prime Minister. Which in effective terms, it means that the Director General of the FCC is a stooge person of the Prime Minister. And you cannot take powers from the DPP and give these powers to the Director General of the FCC. This is not done in any democratic country. Look around, in so many countries, this was the reason why most of the time you will confer powers to one DPP or with a collegial system. At the most, one day, while revisiting the Constitution, if you want to improve on the role of the DPP, maybe my own suggestion is to have a collegial system. This is a possibility. However, it depends on whom you place at the helm of the institution. When referring to the ad hominem law, they were not aiming only at our actual Prime Minister. They were aiming also at the previous DPP and the actual DPP. So they were aiming not only the Prime Minister, but 3 persons at one go with one shot. This is what they wanted to do. And another important point, unlike the DPP, very important point, you will see that the DPP enjoys what is known as security of tenure. Security of tenure, which is guaranteed by Section 93 of the Constitution. You cannot just put in the DPP and then you vote him out. No, this is not done. You have to follow strictly the provisions of Section 93 of the Constitution. Whereas the post of Director General of the FCC, at any time, you can boot him out. And this is not acceptable in a democracy. So, security of tenure, I would say, is a sine qua non condition to ensure independence, impartiality, and above all, integrity. And whether these people who were at the FCC or the ICAC, whether at that point in time, they commanded integrity. Integrity, Madam Speaker, is very important. And you will see that the DPP is a servant of the Constitution and the state, and public interest above all, but not to the PM of the day. He is guided by the Constitution and, as I mentioned, by international standards. Now, another very important point, Madam Speaker, by the fact that the DPP is the sole authority to prosecute, this will ensure uniformity and the use of objective standards. So once more, I would reiterate to say that the spirit of the Mauritian Constitution that is beautifully defined in the enlightening article of Professor Davis. This is a must for you, for everybody to read. Go and read that article, Constitutionalism in a Plural Society. 2 things here. One, we are in a plural context, in a plural democracy. And second point, very important, we are in a small jurisdiction. Reality and perception of bias exist, and Des Smith in this beautiful article explain how there are certain unique features in our Constitution. So allowing the FCC to prosecute did not guarantee uniformity and consistency. So at the same time, you will see that we had a system of check and balance when it comes to the DPP. You could have judicial review, but not with the FCC. So, Madam the Speaker, I will stop here. And to conclude, I would say, yes, this Act of Parliament, the FCC, was an ad hominem law. It violated basic principles of democracy. It violated the principles of separation of powers. And this is a shame for the previous regime to tamper with our democracy, human rights of Mauritius. Thank you for your attention.
Thank you. Mr. Bichu, try and keep an eye on the time as well. Yes, on your whip
She'll
as
do
well.
the job. Merci, Madame la Présidente. Lorsque j'écoute les orateurs précédents, je vois qu'il y a parmi des éminents légistes, des avocats, un spécialiste de la finance. Donc, les avocats, ils ont abordé ce sujet, ce problème, sous le thème d'une approche très, très légaliste. Et moi, de par ma formation, je vais essayer d'aborder ce problème, qui est effectivement un problème, mais avant tout, est un problème démocratique. Donc, lorsque j'ai étudié ce problème, j'ai essayé de comprendre. Je faisais ce qu'on appelle la généalogie de ce problème. J'essaie de comprendre comment ça se fait que dans l'histoire de notre démocratie, il y a, sauf erreur de ma part, il y a eu 5 tentatives d'amender la Constitution. 5 fois, ils ont amendé la Constitution. Et à chaque fois, lorsque je regarde, le MSM est au pouvoir. C'est le MSM qui touche à la Constitution. Je ne dis pas que c'est mauvais, mais essayons de creuser un peu plus loin. Pour comprendre cela, je regarde la composition de cette Assemblée. Je constate qu'il y a à peu près 9 partis politiques représentés. Mais j'essaie de comprendre, dans l'histoire de ce pays, comment ça se fait, il n'y a que le MSM qui, lorsqu'ils sont au pouvoir, touchent aux fondamentaux de notre société. Et je reviens justement.
Je peux me permettre de vous
Oui, madame.
arrêter. Il y a d'autres gouvernements qui ont amendé dans le bon sens.
Oui, je suis d'accord avec vous. Moi, je dis pourquoi...
Faut pas non plus penser qu'il n'y a eu que ce type d'amendement constitutionnel.
Je suis tout à fait d'accord, c'est pour ça que je dis qu'il touche aux fondamentaux de notre démocratie. Donc ici, le problème qu'il s'agit, on touche à quoi? On touche à la liberté du directeur des poursuites publiques. Il ne s'agit pas, comme certains de mes amis l'ont dit, de réduire le pouvoir du DPP. Il s'agit de confisquer, d'arracher les pouvoirs du DPP. Donc, lorsque je fais une analyse de cette salle, je regarde les partis politiques. Pourquoi nous avons remporté les élections 60-0, madame. Il y a 64 membres qui sont dans la majorité. Nous avons la majorité absolue pour amender la Constitution et pour faire ce que le MSM a fait. Si on avait comme objectif, par exemple, la revanche politique, on aurait pu amender la Constitution et tous ceux qui ont commis des offenses, des crimes contre la République, nos institutions, les finances publiques, ils seraient derrière les barreaux. But why don't we do it? Parce que nous sommes républicains et démocrates. Si j'analyse plus profondément sur les 9 partis politiques représentés ici dans le Parlement, ce n'est pas une surprise, il y a un seul parti qui n'est pas républicain. Nous sommes tous républicains. Le Parti travailliste, le MMM, Résistance, Nouveau démocrate, même le PMSD, nos amis Rodriguez, ce sont des partis issus de la République. Mais qu'est-ce que le MSM? Le MSM est avant tout un parti qui n'est pas républicain. C'est un trust. C'est une propriété privée de la famille Jagna. Et lorsqu'on gère un pays en tant qu'un démocrate, et lorsqu'on gère un trust, en tant que gérant d'un trust, une entité privée, voilà, c'est ce qu'il arrive. On essaye d'instrumentaliser toutes les institutions possibles au profit des gestionnaires de ce trust. Voilà symboliquement ce que le MSM a voulu faire avec l'office du directeur des poursuites publiques. Je prends l'exemple. Lorsqu'ils ont introduit, Madame la Présidente, le Prosecution Commission Bill en 2016, contextuellement, pourquoi l'ont-ils fait? Parce que les charges qu'ils avaient mises à l'encontre de l'ancien Premier ministre, l'une après l'autre, les charges étaient, à juste titre, abandonnées par l'office du DPP, où l'ancien Premier ministre, il remportait ses procès où il y avait des non-lieux prononcés par la magistrature. Donc, que faire à ce moment-là? Ils ont essayé d'introduire le Prosecution Commission Bill en 2016 avec, comme objectif, the issue of directions by the Prosecution Commission, qui était un corps politique, appointed by the executive, et l'exécutif est un corps politique, donc avec un agenda politisé, to the Director of Public Prosecutions. Donc, il voulait tout simplement faire tomber le docteur Navin Ramgoolam. Ça n'a pas eu lieu. Rebelote avec FCC Bill. Donc, nous voyons qu'il y a une constance dans la logique du MSM. Il y a une constance d'éroder et d'approprier les pouvoirs, non seulement pas de l'office du DPP, mais toutes les institutions possibles du pays. J'appelle cela l'intervention et l'ingérence nauséabonde, machiavélique du MSM. Il y a plusieurs exemples, madame. Il n'y a pas que l'office du DPP. Nous avons eu, pour la première fois dans l'histoire, des appointments à la commission électorale.
Excusez-moi.
Oui, madame.
Il vous reste 3 minutes. Essayez.
Ouais, je vais essayer de conclure.
Non, non, mais essayez de vous concentrer sur le projet de loi.
Je viendrai, madame. J'y reviendrai. Il y a eu plusieurs exemples, comme la commission électorale, la tentative de l'arrestation du DPP, le complot du free-free-du. On oublie le phone tapping. On a vu comment le commissaire de police donnait des instructions pour faire arrêter,
No, no, I'm trying to do it by myself.
d'arrêter l'honorable Duval. L'interventionnisme du MSM s'est même étendu jusqu'à la presse. Par cela, ce que j'ai envie de dire, cette tendance à vouloir s'accaparer des institutions de l'État et de le mettre au profit du MSM, c'est ce qu'ils ont essayé de faire avec ce bill. Et je félicite ce gouvernement et notre attorney général qui est venu avec cet amendement, non pas comme je vous ai dit, pour, on va dire, donner la liberté à l'office du DPP en matière de poursuite et d'arrêt de poursuite, mais aussi, on a essayé, on a empêché la création d'un monstre politique qu'aurait pu être le FCC. On a donné plusieurs exemples. Si on a, par exemple, je prends l'exemple, rien qu'en ce qui s'agit de l'appointment du directeur général. Essayons d'évaluer le calibre. D'accord? Pour ce qui s'agit du DPP, no person shall be qualified to hold or act in the office of the Director of Public Prosecutions unless he is qualified for appointment as a judge of the Supreme Court. C'est dire la carrure d'un homme qui doit représenter l'office du DPP. Et on a voulu faire quoi? Le remplacer par qui? Navin Bikari. Ce même Navin Bikari, qui lorsqu'il y avait le procès de Maître Point, il a changé de version du jour au lendemain dans ses submissions au Privy Council. Comment voulez-vous que le peuple fasse confiance à cette substitution? C'est pas possible, il n'y a pas de comparaison entre un DPP digne de ce nom et un Navin Bikari. Voilà, je terminerai par dire, madame, je dois respecter mes 10 minutes, je vais terminer par dire que nous avons sauvé la démocratie. Nous avons restauré la confiance dans le processus judiciaire. Et John Locke et Montesquieu doivent se réjouir dans leur tombe. Nous avons restauré la séparation des pouvoirs. Merci, Madame la Présidente.
Minister Rampol. And then you,
Madame la Présidente de la Chambre, puisqu'on parle aujourd'hui aux amendements des pouvoirs d'une institution, le bureau du directeur des poursuites publiques, permettez-moi de dire ceci. Il y avait un temps dans ce pays où nos institutions supposément indépendantes étaient muselées et enchaînées, où on ne pouvait plus faire respirer la démocratie. Je ne parle pas, Madame la Présidente, de l'ère pré-indépendance ou coloniale. Je parle de l'année dernière, la période de 2019 à 2024, où le régime, l'empire MSM, était au pouvoir. Et cet empire qui voulait faire de Maurice un pays autocrate, Madame la Présidente, comme le Premier ministre nous a révélé mardi dernier, pendant la PNQ, le PMQT, on avait une période, la période dont j'ai mentionné, on avait des bail-lookers du MSM. On avait aussi des bail-écouteurs du MSM qui mettaient le téléphone à l'écoute, sur l'écoute. Et, comme avait bien dit le Premier ministre, personne n'échappait à la surveillance étatique. Qui veut dire que nos droits à la vie privée pendant cette période n'existaient plus sous le régime MSN. Un autre exemple, le plus flagrant, Madame la Présidente. Et ça, les Mauriciens le suivaient en live chaque semaine. C'était la manière dont les travaux dans cette auguste assemblée étaient arbitrés. Une institution aussi importante que le Parlement, supposée être la voix du peuple, arbitrée par un speaker hautement politisé. Ces rulings n'avaient ni queue, ni tête, non-sens. Je me souviens pendant la campagne, Madame la Présidente, l'honorable DPM avait dit que si nous retournions au pouvoir, on va faire enlever tous ces rulings du hands-on. Et je crois que c'est temps de le faire. Et c'est la même chose qu'on a voulu faire, Madame la Présidente, avec la loi sur la FCC, introduite l'année dernière pour remplacer l'ICAC. Cette loi était pire que la loi sur l'ICAC. D'ailleurs, l'ICAC, en tant que Law Enforcement Agency, même sans les pouvoirs de décision sur les poursuites, était déjà hautement controversé. Même l'ICAC, sans les pouvoirs de poursuite, était hautement controversé. Et vous vous souvenez, Madame la Présidente, puisque vous êtes avocate vous aussi, vous vous souvenez du jugement d'une magistrate sur les contrats alloués pendant le Covid. L'ICAC était taxé de undergoing selective investigation. Et on sait déjà la liste de ces nombreux cas qu'on appelle des high profile cases dénoncés à l'ICAC, mais qui pour des raisons qu'on sait n'a pas eu d'aboutissement à ce jour. Mais on aurait cru, quand on avait passé la FCC, on aurait cru que le MSM allait se ressaisir, voilà, et qu'on allait nous proposer finalement une loi pour remédier à la situation. Mais on nous a proposé une loi sans précédent, pire que le Prosecution Bill proposé par le père Jagnat. Et qui avait fait le PMSD prendre la porte de sortie pour re-rentrer après. C'était le FCC, la loi FCC qu'on avait proposée, c'était une loi exceptionnelle et qui frôlait l'inconstitutionnalité, entachait les principes de séparation de pouvoir et menaçait l'état de droit. C'est ce que nous avons été proposé sous la FCC. Et même Bicari. C'était très clair, Madame la Présidente. C'était une tentative délibérée à travers un simple projet de loi d'éroder l'office du DPP de ses pouvoirs sacro-saints, ceux d'instituer et d'entreprendre des poursuites dans tous les cas criminels, inclus les crimes financiers. Pire, ce qu'on a voulu donner, on a donné ces mêmes pouvoirs, les pouvoirs constitutionnels, à un dominé politique, le directeur de la FCC. Madame la Présidente, j'étais surpris pendant les débats sur le FCC Bill. Comment certains politiciens, je ne dis pas tout, certains politiciens, chevronnés et expériencés, qui étaient supposés de donner l'exemple, se contredisaient avec ces mêmes principes qu'ils défendaient dans le passé. Parmi, il y avait l'honorable Colin Dabelou, qui disait être le parrain de l'ICA, puisqu'il avait lui-même présidé le Select Committee sur la fraude et la corruption en 2001. Et vous savez, Madame la Présidente, ce qu'il avait dit dans le rapport sur le Select Committee sur la fraude et la corruption. Permettez-moi de citer un extrait, Madame la Présidente. Il disait sur les pouvoirs de l'ICAC et du DPP, il disait ceci. We have read with alarm the considered opinion of some commentators who feel that ICAC must shoulder its responsibilities all the way and itself conduct the prosecution of cases it has investigated. On avait proposé à cette époque-là que l'ICAC aurait dû avoir les pouvoirs de poursuite et d'investigation. Mais lui, l'honorable Colin Dabelou, en 2001, n'était pas d'accord. He said, we do not agree. Alors, il vient justifier cela en disant que, by virtue of Section 72 of our Constitution, the DPP has the sole and unfettered control over criminal prosecutions. Il dit, nothing that has been said can persuade us that an exception should be made in respect of fraud and corruption. We believe that it is the DPP and the DPP alone to control what has been done by ICAC in the course of the investigation and to decide whether the investigation should result in a prosecution. Il continue, il dit, the DPP is a highly respected institution in this country. The DPP's decision may be found to be wrong, but the DPP must continue to act independently. To immerse the DPP in conquering two parts of investigative process is to cloud the DPP's judgment from the very start. It would also be wrong to concentrate into ICAC the task of intelligence gathering, investigating, and prosecuting at the same time. This would lead to the creation, regardez ça, this would lead to the creation of a monster who would soon get out of control by reason of this overconcentration of power. Et c'est ce qu'ils ont proposé, c'est ce qu'ils ont venu à faire avec la FCC, Madame la Présidente. They have created a monster. Heureusement pour le peuple, la population a réagi. La population a réagi. On a gagné Et on a restauré aujourd'hui, et je félicite l'Attorney General, je félicite le Premier ministre, on a restauré le pouvoir constitutionnel du député. Madame la Présidente, je ne vais pas être long. Vous savez, there is one simple and basic reason. Et les légistes vont le savoir. Why the power to prosecute should remain with the DPP. It's because the DPP is not a political nominee, but an independent judicial officer. When he takes his decision, he doesn't look at your political color. He acts in the public interest, as per the code of prosecutors, in order to uphold the integrity of the judicial system. And most importantly, he does so without fear or favor. He is only answerable to one institution, the Court of Justice, not to the Prime Minister, not to the leader of the opposition. So alors, c'est clair, Madame la Présidente, que le MSM voulait créer, comme je l'ai dit, un monstre politique. C'était une loi régressive et encore une fois, je remercie le Premier ministre et l'Attorney General d'avoir pris l'initiative de redonner à notre DPP son indépendance sur toutes les poursuites criminelles. Merci, Madame la Présidente.
Thank you, Madam Speaker. Madam Speaker, let me say at the outset that in the PMSD, we welcome the amendments being brought by the Attorney General. We welcome it because we have always in the PMSD fought for independence of institutions. We welcome it because under every PMSD government there has been the workings of institutions independently. We welcome it because, as rightly pointed out by speakers before me, the PMSD have left its mark on this country's destiny throughout its years of existence, through the positions that it has taken to strengthen our Constitution, to strengthen the independence of institutions, and to allow for institutions to work as intended by our Constitution. Madam Speaker, there is une différence de taille, however, with this FCC Act and the Prosecution Commission, which we tend to forget here in the debate. The Attorney General has embarked on speaking on the appointment, and that was the crux of the matter for the Prosecution Commission. It was not that it would exercise already the powers of the DPP. It was that in the first proposal, the first draft, the Prime Minister would appoint directly the President of the Prosecution Commission, and the Prosecution Commission had the power to direct the DPP to take or not to take an action, and refusal to abide by its directions would lead to the sacking of the DPP. That was the Prosecution Commission, and that is the crux of the matter. Appointment and termination of appointment. And it is a missed opportunity, however, Madam Speaker, the more so that the office is vacant at the moment as the Director General of the FCC, that we have waited and that we are missing the opportunity to change the mode of appointment. We've always, in the PMSD, Madam Speaker, always strived to have, for institutions like the FCC and the ICAC before that, a mode of appointment similar, if not exact, to that of the Director of Public Prosecution or the Chief Justice through the Judicial and Legal Services Commission. And I hope that this is the kind of amendment that the Attorney General is thinking of bringing to the House, I hope, in a not too distant future. Because why, Madam Speaker? The ICAC, before the FCC, rightly pointed out by the Honourable Utim, did not have the powers to compound, did not have the powers to initiate prosecutions or not to send reports to the DPP when it decided not to prosecute, not to carry out a further investigation. What power did it have? It had virtually the same powers as the SCC, but that did not stop the ICAC from putting those inquiries, those declarations that were not favorable to government dans le fond du tiroir. Since its creation, the ICAC has been like that. So what changes now, Madam Speaker, if the appointment is virtually the same? What difference are then the appointment between the ICAC and the FCC, one might ask? Simply that in the FCC, it is the President who appoints after recommendation from the Prime Minister, after consultation with the Leader of Opposition, whereas before it was the Prime Minister appointing after consultation with the Leader of the Opposition. But, Madam Speaker, we have heard so many times, in fact, the Leader of the PMSD himself as Leader of the Opposition, so many times complained that that consultation exercise basically amounted to merely sending a letter to the office of the Leader of the Opposition and then completely ignoring any consultative views that was provided to the Prime Minister, and therefore it is basically a rubber stamp exercise. So, Madam Speaker, that does not change. We will fill the position, and that is a question. Will we fill the position once again and then change the mode of appointment like it has been for the head of state? Too late, too little? Or will we seize this opportunity and change the mode of appointment before filling in that vacancy? And that is a question I hope the Attorney General will answer. So, Madam Speaker, that power then to cover up, to use the words of Honourable Utim, is still here, depending on the appointments that we make. Unfortunately, the wrong person at the head of the institution will be a déjà vu. And therefore, to ensure that the appointment process is without any doubt that of independent, then we will, Madam Speaker, unfortunately, still raise these questions to Parliament. So therefore, Madam Speaker, I hope that this is replied. Will we fill the position pending the new body that is being promised? If so, are we filling that position after amendments, after the new legislation, or are we contemplating to fill that position now? And, Madam Speaker, so that is simply what I wanted to say. On the whole, though, Madam Speaker, I have to say something. Truth is that the PMSD in 2016 has no doubt saved the destiny of this country with the Prosecution Commission. Truth is that institutions have shown, again, where one government uses too much power or too much influence, that virtually nearly all institutions can be influenced. So therefore, this change that is being promised starts with security of tenure at the level of the SCC and at the level of all other institutions that have been used so often to oppress in the past. Thank you, Madam Speaker.
Thank you very much. Thank you. Honourable
Yes,
Deputy
yes, Madam
Prime
Speaker. I won't spend much time on what we've just heard. He's sitting next to one of the culprits. They've made of Mauritius, they tried to make of the DPP.
Minister cannot treat me
He
as
has not
culprit.
finished his sentence.
No, I want him to withdraw what he just said, Madam Speaker.
If we start like this,
Then the person who spoke just before him, the member, told us with the financial crime bill what crime was committed against democracy, against the DPP, what they tried to do and what they did. And now he comes and gives us lessons. Shame on him, Madam Speaker. Shame. Well, let me get to more serious things.
Speaker, may I please?
Oh, Madam Speaker, I hope you won't do that every 5 minutes with your permission.
Remove the word culprit.
You are a culprit, you are guilty devant l'histoire.
I think you will take this as being your being in a party, and they're talking.
Somebody as culprit.
On va vous a condamné. You are a culprit. So, Madam Speaker, I'll get to more of a happy hour.
Madam Speaker, if I may, point of order. It is clear in the standing orders that we may not comment on the conduct or character of the member without bringing a substantive motion. Therefore, I think this would be the proper course of action, especially since there are 64 members.
Everybody speaking here has been condemning what you've done as a government in the case of MSM and as a culprit with that government until the last general elections.
You cannot use these words.
So, Mr. Speaker, I'll do away, and I'm hoping that they'll walk out. But please don't order them out. It's not worth it.
You're making
Let me get to more serious things, Madam Speaker.
making very difficult for me.
Allez. Pas qu'à attendre. Madam Speaker, Alpandido. You're staying?
You want there to be no opposition?
No, there is one behind you. Madam Speaker, let me get to more serious things. Madam Speaker, this government, our government, has a very, very ambitious democratic agenda. As you know, Madam Speaker, we mean to make of Mauritius une démocratie exemplaire. And that is what we are doing today, and we'll keep on doing. And we want to make of Mauritius une démocratie exemplaire. Après 10 ans de viols et de crimes contre la démocratie. C'est notre but. Et faire de l'île Maurice une démocratie exemplaire. Ça veut dire quoi? Je ne parlerai pas trop longuement là-dessus. C'est faire quoi? C'est d'abord rendre au Parlement toute sa dignité, tout son rôle. Et c'est déjà fait, pas complètement. Nous avons encore beaucoup à faire. Mais déjà, ce que nous avons fait pour rendre au poste speaker, au Parlement, ces lettres de noblesse, c'est extraordinaire. Ensuite, la MBC, c'est déjà fait, mais nous avons encore beaucoup à faire. Mais si on prend la peine de regarder la MBC, après 10 ans de propagande quotidienne, nous allons dans la bonne direction. Faire de l'île Maurice une démocratie exemplaire, c'est faire les élections régionales et mettre dans la Constitution la démocratie régionale. Même là aussi, c'est déjà commencé. Les élections municipales sont derrière la porte. Et nous continuerons dans cette direction, Madame Speaker. Faire de l'île Maurice une démocratie exemplaire, c'est réussir une bonne réforme électorale, que nous réussirons cette fois. Après avoir essayé dans un passé pas trop lointain, le Premier ministre, moi-même, tous ceux qui comprennent quelque chose à la démocratie. Faire de l'île Maurice une démocratie exemplaire, c'est de venir de l'avant avec un Protection of Information Act, que nous ferons, qui est dans notre programme. Faire de l'île Maurice une démocratie exemplaire, c'est en finir avec les provisional charges qui ont existé jusqu'à présent et qui ont permis ce que nous savons qui s'est passé. Faire de l'île Maurice une démocratie exemplaire, c'est rendre ses pouvoirs au DPP. Nous avons dit que nous allons faire ça. Non seulement rendre ses pouvoirs aujourd'hui au DPP, mais consolider ses pouvoirs. Et je reviendrai là-dessus à la fin de mon intervention. Je peux parler encore, mais faire de l'île Maurice une démocratie exemplaire, pour nous, ce n'est pas du blablabla, comme ce que nous venons d'entendre. Nous sommes en train de faire vraiment de notre pays une démocratie exemplaire, et nous sommes fiers de ça. Aujourd'hui, c'est un début, c'est un first step. Mais un first step très important de rendre tous ses pouvoirs au DPP. C'est déjà énorme. Et c'est pourquoi moi aussi je salue, bien sûr, c'est une décision du gouvernement, pas de l'Attorney General. C'est le gouvernement, à travers l'Attorney General, qui a fait un exposé magistral un peu plus tôt. C'est un premier pas, mais c'est un grand pas pour faire de l'île Maurice une démocratie exemplaire. Le but de ce bill, de ce projet de loi, to restore the prosecutional powers of the DPP. C'est ce que nous faisons aujourd'hui. Ce que nous allons faire dans l'avenir, je reviendrai là-dessus à la fin de mon intervention. Aujourd'hui, nous rendons au DPP tous ses pouvoirs, usurpés par le MSM et ses complices jusqu'aux dernières élections. Il ne faut pas l'oublier. Des crimes qui ont été commis. Aujourd'hui, nous rendons à un DPP exemplaire, lui aussi, tous ses pouvoirs. Mais nous n'allons pas nous arrêter là. Déjà, c'est énorme. Mais nous n'allons pas nous arrêter là. Nous viendrons, l'Attorney General, le gouvernement, nous viendrons avec un nouveau Financial Crimes Bill, à moins que ce soit remplacé par une autre loi, encore plus démocratique, encore plus d'avant-garde que ce que nous avons jusqu'à présent mentionné. Ça viendra. Aujourd'hui, ils sont plus pressés que tout le monde, ceux qui ont essayé de tuer le DPP. Aujourd'hui, tout que nous n'allons pas assez vite. Enfin, il a pris son temps, mais c'est arrivé. Happy Hour. Nous viendrons avec un full bill ou une loi encore plus démocratique, encore plus solide pour remplacer le Financial Crimes Commission Bill d'aujourd'hui. Nous avons même dit que nous allons amender la Constitution. Nous en discuterons des détails au gouvernement, parce qu'il y a des nuances là-dessus. Comment le faire? Faire quoi exactement? Mais nous avons dit que nous allons amender la Constitution pour que les pouvoirs plus étendus du DPP soient inscrits dans la Constitution. Nous viendrons avec cela après un full discussion dans le gouvernement. Est-ce que nous viendrons avec un DPP Act? S'il le faut, oui, c'est l'Attorney General qui nous conseillera. Est-ce que nous viendrons donc avec un full DPP Act? Tout ça, nous le ferons. Et je vous dirai franchement, Madame la Présidente, à chaque budget que nous avons voté depuis des années, me dit ça galoupé. Quand je vois que le Local Government Service Commission, une institution très importante, mais le Local Government Service Commission, dans nos estimates, stands alone. Ils ont leur budget. Un stand-alone sous le Premier ministre d'une façon générale, alors que le DPP tombe sous le vote de la tournée générale. La tournée générale d'aujourd'hui, on peut lui faire confiance, mais dans le principe même, il faut que le DPP, dans les estimates, nous allons lui donner tout ce qu'il a besoin comme pouvoir, comme indépendance dans la Constitution, si nécessaire, à travers un DPP Act, mais dans les estimates avant tout. Nous allons voter un prochain budget, mais nous verrons à ce que le Office of the DPP stands alone, comme une liste d'institutions qui stand alone. Donc tout cela, nous avons dit que nous allons le faire et nous le ferons. Aujourd'hui, c'est un pas, premier pas, mais un pas de géant. C'est déjà énorme. Nous allons voir bien qu'est-ce qu'il faudra mettre quand nous amendrons de façon plus poussée la loi, mais déjà, c'est énorme, c'est fantastique ce que nous sommes en train de faire. Donc, je pense, j'avais envie de pleurer quand j'écoutais, je crois que c'est le ministre Ramphol, qui citait Ivan Collen David en 2001. C'était sous notre gouvernement, et vraiment, ça a été un ami personnel, mon avocat, un vrai démocrate, qui aujourd'hui finit comme eux, avec le MSM. Mais c'est triste à pleurer. Mais enfin, c'est la vie. Mais nous sommes décidés, le Premier ministre, moi-même, le Parti travailliste, le MMM, Résistance et Alternative, Nouveaux démocrates, nous tiendrons parole. Aujourd'hui, c'est un premier pas. Nous ferons beaucoup d'autres pas, le plus rapidement possible, pour faire de l'île Maurice vraiment une démocratie exemplaire. Merci, Madame la Présidente.
Madam Speaker, the Attorney General has been so clear and precise, and many orators, including the Deputy Prime Minister, others, but I will try not to repeat what has been said. The Attorney General explained, comprehensively explained, the need to restore constitutional order. This is why these amendments to the Financial Crimes Commission Act are necessary until we repeal the FCC Act, as announced in the presidential address, I think paragraph 10. Today, what we are enacting, as the Deputy Prime Minister has just said, as others have also said, this is merely the starting point of a broad transformation. For years, our legal and investigative framework have suffered from inefficiency, political interference, and a lack of accountability. The FCC, Madam Speaker, also was used as the tool for persecution of opponents of the regime, as so many have said before me. We must do more than patch up the system. We must build anew. That's what we are doing, the first step of what we are doing. The people of Mauritius expect real change. They elected us for this, and we will deliver, I can tell the House. Our goal is not simply to correct the past mistakes, but to construct a modern enforcement body that operates beyond political cycles. By that I mean, whoever comes, they won't come back, but whoever comes, it must be beyond the political cycle and effectively combat financial and organized crime. This will be our legacy. That is why, Madam Speaker, this government will in due course, as others have said, we will replace the Financial Crimes Commission Act. It will be replaced we said that in our presidential, with a national crime agency. A new institution which will be independent, well-equipped, professionally structured to tackle financial and serious crimes decisively. All those who thought that they would have immunity, as Minister Utim has explained it so well, they thought they would be protected, they will have immunity, or they belong to such a community that you can't touch them. This, no. If they commit financial crimes, I ask them to think again, because we'll be ruthless against those who interfere with that agency. Building a credible, investigative authority is not an easy task. It is complex. It will require careful planning and expertise with a solid legal framework. We must create an institution that people can trust, not what LICAC was. They must be able to trust them. It must be efficient, and it must be, I stress again, free from any external influence. No one will be allowed to intervene. And we will draw inspiration, Madam Speaker, from international best practices and also seek the views of those who are already involved in our criminal justice system. That is why we need this amendment. It's a first step so that the institution respects our democratic principles until we replace it. And we need to restore, Madam Speaker, the public confidence in the institutions that we bring up. Ensure that justice is pursued with rigor and impartiality. With today's amendment, we are securing the independence of the Director of Public Prosecution. In fact, we are restoring what was taken away from the Director of Public. When did you see, Mr. Speaker, a Commissioner of Police challenging the DPP in court? Never happened before. It just shows the mentality of the MSM. Even that they went to the extent. They tried to arrest the former DPP. He had to run away from his house and get protection from the judge in court. This is why we have to have this new National Crime Agency, which will be empowered, as I say, to conduct inquiries professionally without any favoritism. Nobody will be allowed to intervene with them, interfere in the conduct of the investigation. They will have specialists, skilled, financial investigators. I don't know whether some try not to do the job properly. We have this. They derail the inquiry, and you see the guilty goes away. This will not happen. There will be financial investigators who will know what to do, and they will have the decision to prosecute. The decision will rest with the DPP. They will do the investigation. They must be separate. It cannot be together. The agency will have full authority to investigate. And the cases will be based on facts, not on personal or political considerations, on facts. And then there will be a scrutiny at the apex by the prosecution services. So you'll get checks and balances. This is why we want to have also a prosecution service, which will be set up under the aegis of the DPP. During the past 10 years, Madam Speaker, there has been unanimous condemnation of the ICAP. Unanimous. It became politically, a politically perverse institution. And at the helm, a self-appointed monarch. To show that immoral minds know no limits when in power, the previous regime, I think I find it an insult to the intelligence of Mauritians. Adopted the Financial Crimes Commission Act, not only to prosecute opponents, but to stop certain investigations, as my honorable colleague, Honorable Utim explained so clearly. Files were closed. Angus Road is an example. You gave many examples. It became paradoxically a symbol of state corruption, ICAC. It violated the constitution of Mauritius, attacking the functions of the DPP. This was a dark chapter of our history. The former DPP himself has said that the FCC was created to usurp the power of the DPP, and furthermore, with the mass surveillance that we know happened, including members of the judiciary, including everybody, in fact. The former DPP said he realizes now that what was being said in his office by his own people, maybe on the phone, the police knew before they go to court, they knew. Is this what we want for this country? Then we abolish everything. But this will change. A red line, I must say a very red line, has been crossed. This cannot be. Their minds were so corrupt that they were obsessively bent on replacing the office of the DPP by the infamous, what I think it was called Public Prosecution Commission. They appointed their own, I could say, scoundrels at the helm of all criminal prosecutions in our country. Honorable Juval himself says he is not here. How is his own father resigned? There were many other reasons probably, but that was what tipped him to resign. What people should understand is that the decision to introduce the bill was not by itself an isolated act. If you look at it, it was a broader scheme by the MSF. Prosecution, the DPP being tried to take the powers away from the DPP, protecting those close to the regime, or those who would dare to go and speak in their eye, in their ear. All this was happening. What they did was confiscate the major institutions of the country who were supposed to uphold justice and democracy in our country. The goal of my government is to put in place a system that those who break the law will have to face the legal consequences regardless of who they are. And certainly not a politique de vengeance, as they did, where charges were brought against political opponents. I was a victim. Charges were brought, and then they tried to concoct evidence, fabricate evidence. You know, lawyers will know what it means. What a dangerous thing to do is to fabricate false evidence. I have been through this. I know what they did. Not a political politique de vengeance, but true accountability. That's what we want. A system where institutions will function freely, diligently, and without any interference. When entrusted to the right individuals, our institutions will ensure that those who have breached the laws, trampled on the rights of citizens, or plundered our nation will not escape justice. And I can tell you, believe me, Madam Speaker, they will not escape. Our priority, Madam Speaker, is to build institutions that serve the interests of the whole nation. Not one clique or one group or one community. No, the whole nation. Not political agendas, not individual ambitions, but the rule of law itself which has to prevail. This is what we're trying to do. The future National Crime Agency will be a model of integrity and competence. Enquiries will be done, I say again, by professionals. And if ever there are leakages, like that has happened just now, we've seen, action will be taken. There will be sanctions. Today marks the beginning of an essential reform. But we will not stop there, as the Deputy Prime Minister said very forcefully. We are committed to delivering a truly robust and transparent framework to uphold justice and combat crime. This is not just about amending laws, change a name, put another name. No, it's about shaping a system that serves all Mauritians. In these efforts, Madam Speaker, I take inspiration from the words of President Mandela, who wrote, and I quote, he said, "I've walked that long road to freedom. I've tried not to falter. I've made missteps along the way. But I've discovered the secret that after climbing a great hill, one only finds that there are many more hills to climb. I've taken a moment here to rest, to steal a view of the glorious vista that surrounds me, to look back at the distance I've come. But I can only rest for a moment. For with freedom comes responsibilities. And I dare not linger, for my long walk is not ended. Yes, we have come a long way. We have come many obstacles, this country. We have benefited from the strides of giants before us. And tomorrow, younger generations, there are plenty of them here, they will carry on across our bridge to the future. But for now, Madam Speaker, there are many hills for us to climb, but we will climb them. Thank you.
Honourable Attorney General, you got a mouthful of proposals.
Mike.
Madam Speaker, having heard what the honourable members of the House had to say today, it is clear that even the opposition has nothing much to say about the very specific amendments brought about to the Financial Crimes Commission Act. Indeed, if I refer to the speech of the Honourable Leader of the Opposition when the FCC Act was put to Parliament last year, he rightly stated, the learned Leader of the Opposition at the time, that if this law needs to be repealed because it would mean the destruction of the office of the DPP and then of our civil liberties. In that respect, Mr. Speaker, he said, this bill is an evil precedent. So I was a bit surprised to hear Honourable Duval today make reference to the fact that this bill, in fact, does not put an end to the possibility of a cover-up. I'll come to that in a minute. On a lighter tone, having heard my learned colleagues of the House speak, since very young I've been dead scared of monsters. I don't like them, especially those created for a specific purpose, here for the dismantling of the prosecutorial powers of the DPP. That is what they wanted to do. And let us be clear, the FCC, as the Deputy Prime Minister and the Prime Minister have said very clearly, the FCC Act will be repealed in due course. And let me reassure my learned friend Duval that he is absolutely wrong when he says the power to cover up still exists. It is not true, and I will explain why. You see, if you go through the very many amendments brought in this bill, you will have seen that the whole purpose of this act is to restore the prosecutorial powers of the DPP in relation to the functions and powers of the FCC, i.e., that is, that when there is the possibility of stopping prosecution, the DPP will have his way. He will know what to do and what not to do. Now, of course, these amendments do not go the whole way, because we wanted to be very specific in order to ensure that these restrictive amendments today will be only a first step. But as the Deputy Prime Minister rightly said, it is indeed a big step in the right direction. We shall restore democracy, make no mistake, and as quickly and as swiftly as possible. So I note that the amendments per se, the specific amendments, have not been attacked in any way. Indeed, there cannot be any attack, as the restoration of public confidence by these amendments is paramount, and this government will not flinch and has gone as quickly and swiftly as possible to bring these first amendments to restore democracy and to make sure that the prosecutorial powers of the DPP are restored. In fine, what we're doing today is simply restoring the powers of the DPP as provided in the Constitution, as all the members of this House have stated today. The new law will come in the meantime, but for now we have plugged a loophole which would have allowed the DPP, which would have allowed the FCC, if it was so minded, to stop an investigation which ought to be prosecuted. As the Prime Minister concluded this afternoon, this is the start of a long road that will lead to greater democracy, which our nation will be proud of and will be, of course, free to live in. Thank you, Madam Speaker.
Thank you. Honourable Attorney General, you have to commend the bill again to the House. You just commend the bill to the House.
I now commend the bill to the House.
And then I need it to be seconded. The Deputy Prime Minister seconded. The question is that the Final Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 be read the second time. Those in favour say aye. Those against say no. The ayes have it. Are we proceeding with committee stage immediately?
Public Bill Committee stage.
Alors. Voilà. Thank you. Okay? You call.
Clause 1, short title. Clause 2, Courts Act amended. Clause 3, Criminal Appeal Act amended. Clause 4, District and Intermediate Courts Criminal Jurisdiction Act amended. Clause 5, Financial Crimes Commission Act 2023 amended.
The question is that clauses 1 to 5, stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The final question is that I do report to the House that the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 has passed the committee stage without amendments. Those in favour say aye. Aye. Those against say no. The ayes have it. And now I will resume the chair. Thank you. Honourable members, I have to report to the House that the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 has passed committee stage without amendments.
Public Bill, third reading.
I move that the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 be read the third time and passed.
Motion needs to be seconded. I'm looking on this side. Mr. Lubin. The question is that the question is that the Financial Crimes Commission Miscellaneous Provisions Bill number 1 of 2025 be read the third time and passed. Those in favour say aye. Aye. The ayes have it. Those against say no. The ayes have it.
Motion.
Honourable Minister of Agro-Industry.
Thank you very much, Madam Speaker. Madam Speaker, let me convey congratulations to the mover of the motion and others for delivering their maiden speeches. Madam Speaker, we've had the privilege to listen to some awe-inspiring speeches. And I feel proud to be at long last in the temple of democracy. And democracy will not only prevail, but under the leadership of Prime Minister, democracy is here today and here to stay. And we have to live up to expectations of a nation. What is expected of us, Madam Speaker? Transparency, accountability, reaching out for a better outreach. And the people, they have spoken. And the resounding mandate is a call for liberty, justice, and solidarity. And what have we witnessed since the last 10 years? Corruption, decadence, and a government whose main agenda was to rip off this country. And when Prime Minister, in a reply to parliamentary questions, stated that the state has been captured, and we have to know the cost of the state capture. That cost has to be computed. On only one item, we were told that the cost was, why? Because Big Brother was watching. But if we compute the cost of state capture, it would run into several billions of rupees. And we have to know who are those who pocketed this money. It is true, as has been rightly stated, we are in a democratic country. And the demarcation line between democratic institutions have to be wide and not blurred. But let me issue a note of warning to those who swell their pockets and probably will end up with a double hernia. Let me tell them, they may enjoy armchair comfortability, they may relax, but the time has come for them to be arrested. Arrested under the provisions of the law, as has been stated very clearly in this House. Yes, the powers of the DPP had to be restored. But I'm sure the DPP is not next to God. Some people say he's next to God. But I'm sure he will motivate his decision in relations to cases of prosecution or no prosecution, cases of major importance. This is democracy. And democracy is prevailing. And when you talk to people outside the ambit of his house, they feel that they are free at long last and at large. And this is the reason why I say. And I say to all of us, those who were in this house during the time that they were in power, we knew what we went through. And as leader of the opposition, I had no choice but to move a motion of confidence in the Speaker only 7 months after the MSM government was sworn in. And we know the circumstances which provoked his departure. And he was, of course, replaced by the gatekeeper of the MSM. But he was not, his appointment did not only make him a gatekeeper, but the appointment, the nomination, was a blatant rape of parliamentary democracy, Madam Speaker. That's what it was. And we knew that but their politics was a politics of collusion. The collusion between the leader of the House and the Speaker. And they turned the House into a walk-in, walk-out parliament, selectively and arbitrarily picking on those who should be called to walk out. This is the democracy, so-called democracy, that prevailed, Madam Speaker. It's over. It's over. Now it's a democracy which is deeply rooted and permeated into the lives of a nation which is on the walk for better freedom, Madam Speaker. So that's why I say, when we talk of state capture, there is a call for responsibility. And those who have captured the state should be made responsible, and they have to answer before a court of justice. Madam Speaker, when we make promises, we deliver. But we deliver in relations to the provisions of the law. We don't act outside the perimeter of the law. We are law-abiding citizens. What prevailed in the past was cronyism prevailing over integrity, Madam Speaker. So, and it is precisely this cronyism which enabled them to hand out indiscriminately land to those who were not deserving. Land to those who were not deserving at the expense of sectors like agriculture and blue economy, because those core sectors were neglected. And I will quote an architect of the Green Revolution of India. I will quote Dr. Swaminathan, and I will say what the message that he conveyed to students and farmers, PhD students. If agriculture goes wrong, nothing else will have a chance to go right. And our nation's food security, Madam Speaker, is at a crossroad. Yet, and I've said it loud and clear, our policy is to eat what we produce and produce what we eat. Unfortunately, we have a high level of food imports in Mauritius, while our local production remains below expectation. And it's a situation which is untenable, one that calls for bold reform and decisive action. Under the previous regime, our food bill skyrocketed to over 60 billion rupees, while local production was left to stagnate. 80% of our food needs is imported. We harvested less than 12,000 tons of potatoes, 8,000 tons of onions, and import more than 20,000 tons of fish or other seafood produce. The bulk of it is from fish farm at a cost of more than 550 million rupees. Madam Speaker, if I tell you that you are an inhabitant of a small island developing state, perhaps with a high vulnerability index, but if I tell you that you're a citizen of the ocean state, I'm sure you'll feel very proud. But Mauritius is a coastal state. UK is not a coastal state. I'm not going to refer to ruling given by tribunal under gloss. Nor am I going to say what was the opinion given by the International Court of Justice, nor the massive vote which we reap at the UN General Assembly, nor what the Prime Minister of UK stated in the House of Commons. No, I was not privy to the conversation which he had with our Prime Minister. But Mauritius is an ocean state, and our sovereignty is as clearly spelled out in our Constitution. But what stops me tomorrow to say that I'm going to give fishing license for any fishing trawler company or any vessel, fishing vessel, to go to any part of Chagos, go and fish and bring the catch to be landed in our port? What stops me from saying this? We are a sovereign democratic state. The Prime Minister of UK in the House of Commons has stated that Mauritius is entitled to its sovereignty, hence the Republic of Mauritius. Why should we be a net importer of fish produce when we can go to any part of Chagos, barring Diego Garcia, if the deal is sealed? We don't have any fisheries partnership agreement. We are on our own. We have the authority, moral authority, legal authority, legitimate authority to fish in our exclusive extended zone, Madam Speaker. So let me say, it's time for us to achieve self-sufficiency. I don't see any reason why we have to be a net importer of fish produce. And when I say self-sufficiency, not only going out for a bigger catch, but I mean key crops like potatoes, onions, and pulses, produced locally, and cross-border initiative for self-sufficiency. I just came back from a summit, of course. Prime Minister gave me this privilege to attend a summit which was held in Kampala on comprehensive Africa agriculture development program. And they wanted us to earmark 10% of our total public expenditure to invest in food production. I made it quite clear to them. There is a threshold that we can use, and there is because we are an ocean state. In as much as we are going to invest in production inland, we have to make sure that we widen the circle of opportunities for those who are going to make the most of ocean state. But we have to modernize, and we have to make sure that institutions deliver. But we need the skills, and we need the commitment. And this leadership is coming from this government. For far too long, there has been indolence in this country. Time to wake up, as we say, arise, awake, and stop not till the goals are reached. And we're encouraging land optimization through agro mapping and land use planning. We are going to set up special agricultural zone together with Landscope, MSI, and Land Use Divisional Agro Ministry. And we will publish a map with clear indices on land suitability for specific crops. India is willing to offer immediate technical assistance to accelerate the process. It's time for us to think positively and invest in digital and precision agriculture, artificial intelligence and biotechnology to boost productivity, strengthening Food Agricultural Research Extension Institute to provide better support to farmers, notwithstanding interland cropping, and land lease will be encouraged for private-public partnership. Madam Speaker, a national insurance policy for agricultural resilience will be introduced, and we're actually at the level of bid evaluation committee. Would you imagine giving the opportunity to every farmer, to every planter, every grower, every breeder to be entitled to an insurance scheme? We said it, and we are going to deliver. The sugar industry, Madam Speaker, is part of our national heritage, and we will ensure it remains viable. Sugarcane is one of the best carbon dioxide cleanser. The previous government failed to protect small planters, allowing the industry to decline. But we will reverse this trend by increasing the sugar price to 35,000 rupees per ton to support small planters. It may vary between 38,000 rupees to 45,000 rupees per ton of sugar. Promoting special sugar for niche market to maximize return, expanding biomass production using bagasse, bamboo, and cane thrash. What did they say? They said that 60% of our electricity needs would be generated from biomass. They were criminals. Today there's a risk of power blackout because they failed to invest in renewable energy. They had no vision. And this is the situation where we are. But my friend, the Minister of Public Utilities and Energy, is forcefully addressing this issue together with the government. Madam Speaker, securing local production, sugar production, and increasing domestic sales for appropriate measures. But you may tell me, how is it you are promising to give planters 35,000 rupees per ton from the proceeds of sale of the sugar? Where will it come? We have a domestic market, and this domestic market will become a guaranteed market with a guaranteed price for small planters. Why is it that the corporate sector from SADC, why is it that the corporate sector from elsewhere should take advantage of our remunerative market in Mauritius? That market should exclusively go to small planters in the name of special and differential treatment. Madam Speaker, would you believe it? Decultivation, and I've met the promoters, are being revitalized with special mechanized projects and increased focus on value-added products such as bubble tea and flavored infusion. Two high value-added projects are being implemented. Let me now turn to the blue economy. And as stated earlier, we are an ocean state and we are all ocean citizens. But we will drive the blue economy by turning the port of Port Louis into a modern port to increase transshipment capacity and global competitiveness, ensuring our country becomes a key maritime hub in the region. And there are 4 criteria which are essential to the smooth running of a modern port: velocity of traffic, fronting insurance policy, bunkering and storage, stable and competitive pricing. We have to draw lessons from the success of how the port in Namibia is being run and managed. It is a success story, and as I say, there are lessons to be learned. Ship chandler is a big business in Malvis port. 40,000 ships ply the sea route of the Western Indian Ocean. We should be a port of call for at least 20,000 vessels. Would you believe it if I say there's no direct shipping line between many African ports and Port Louis, no direct shipping line between Mauritius and India? Under the decadent and filthy regime of the MSM, Mauritius received a low ranking in Container Port Performance Index 2022, reported by World Bank. It came at a measly 327th out of 344 ports globally, an abysmal performance indeed. So, as I've said earlier, we have to expand sustainable fisheries, the construction of a fishing port, and the setting up of an international auction market, strengthening monitoring and surveillance to combat illegal fishing, unreported and unregulated fishing, developing marine biotechnology to exploit high-value oceanic resources, promoting aquaculture as a viable alternative to fishing, to traditional fishing. And Vietnam is willing to share its experience and partner with Mauritius, launching a second national dialogue on the ocean economy to drive policy innovation. The last one was held in 2013. Setting up the largest marine protected area to ensure long-term ocean sustainability, developing blue carbon sinks as part of a commitment to climate change mitigation. We will also implement a national marine protected area to enhance biodiversity and establish a blue carbon sink aligning with our sustainability commitment. Mauritius has a leading role to play on the biodiversity beyond national jurisdiction, Madam Speaker. Madam Speaker, I'm just about to conclude. Let me remind the House that climate change and what we call delay is a direct threat to life in our marine ecosystem, and it is impacting on our marine ecosystem. Direct threat to food security. To build resilience, we will expand reforestation and afforestation efforts to protect soil biodiversity. Introducing smart irrigation systems and water harvesting techniques. The construction of Rivière des Anguilles Dam is long overdue, and the Minister of Energy and Public Utilities has given firm assurance we will deliver. Madam Speaker, I've reached almost to the end of my speech. As we say, we are here today and here to stay, but here to deliver, and as an alliance which understand the meaning of changement. Changement is going to be meaningful, effective, and the only factor which remains constant in this life is change. So we have opted for change, hands up, and outreach to one and all. Thank you very much.
Yes, Madam Speaker, thank you.
Yes, honourable member.
Yes, Madam Speaker. So, Madam Speaker,
Speak up, speak up.
I am speaking up. I am speaking up. I'm just
Getting organised.
yes, trying to. Madam Speaker, the government program, like most government programs, sounds good on paper, but then the real test is always in the delivery. It is an ambitious program. It is regretfully vague in places where clear promises have been made and sometimes hard to read. For example, between the line of free transportation, I still have had some difficulty in understanding what government meant in the paragraph that we will put everything in place to pave the way for free transportation, whether or not that means that we will see free transportation. Basically, Madam Speaker, the program is ambitious, it sounds good, but the proof of the pudding is in the eating. And we will see to it that government implements its agenda, and we will comment as and when we see these being done. I've said it before, ça mérite d'être dit, le gouvernement a une chance que peu avant ont eu pour apporter un vrai changement. Et même si, par exemple, en tournant la seconde page du programme, on voit de belles promesses. Government will foster ethics and integrity as core values. Donc on voit une promesse d'intention de changer réellement la gouvernance. Mais je peux m'empêcher, Madame la Présidente, de faire un parallèle entre le cas des dépenses électorales à l'époque des Keystone Papers, qui avait été à l'époque repris ici dans la Chambre par le leader de l'opposition d'alors, l'honorable Mohamed, qui avait été repris, bien sûr, par la résistance et alternative, sur les dépenses électorales au-dessus du palier légal, qui, à juste raison, avait été fait, on en avait fait tout un plat, et qui avait même en suivi de private prosecution en cours de justice, et ici, dans le cas de déclaration faite par voie d'affidavit.
This is not on the program.
Well,
It's not on the program.
ethics and integrity is.
Yes.
And if you allow me, Madam Speaker, electoral reform, political financing, free and fair elections, all of which is on the program. So this falls within that. Now, again,
But
And-
except you don't go in the nitty-gritty of what you just said, because it's still pending. Okay?
if you will not preempt what I'm saying, and allow me to deliver my speech, being the only one here, save and except for Franco Guia, who's independent of the opposition. Right.
Carry on, carry on.
Thank you. What I was saying, Madam Speaker, again, we do not need to wait for a constitutional amendment to bring about free and fair elections, to bring about the principle of ethics and integrity in our electoral process. And we should treat matters of the same nature similarly. And this is why I can only but recall how Keystone papers are being treated, and I can only see here the paradox that this is being treated as if it didn't happen. In fact, Madam Speaker,
I don't follow you. Can't follow you.
well, si j'en crois aux déclarations qui ont été faites par certains membres du gouvernement, qui sont satisfaits des explications, then I understand that it is not an issue. You want me to, I don't want to go and name who said what. They will recognize themselves, but it has been done. Madam Speaker, this is a speech on the government program.
Yes.
It's very wide and has been commented largely. I will simply say, Madam Speaker, that we do not need to wait for the implementation of that part of the constitutional amendments to put the ethics and integrity in practice. If members of cabinet are now embroiled in what appears to be the start, according...
Yes.
A real point of order. We know what's taking place. We know that the electoral commissioner is looking into the matter, I'm sure. If it's gone to the police will be looking into the matter, but he can't in the House interfere into an ongoing inquiry, if there is one.
Really, you can't. All right. I rule that. I tried to tell you. It's not sub judice yet,
Yes.
but it is still being investigated.
Like all cases which are referred to from the past government, we understand. Like all of them. What I'm going to say simply is that ethics and integrity
carry on
would
with ethics.
entail resigning from cabinet until the provisions, in fact, of the law. There is a mechanism in the law to apply, as you may know, Madam Speaker, until those provisions are satisfied. That, in my opinion,
But you
I am merely commenting, would be what needed to be.
You cannot.
The more so, Madam Speaker,
Honourable member, you have been sitting here. I didn't even hear. Honourable member, you have been sitting. May I? Honourable member, you've been sitting in this chair. You know how very difficult it is. I gave a ruling. Please carry on with the government program.
Speaker, would you like me to quote?
Yes,
Okay, I will quote.
but do not,
Yes, I will quote.
you know.
So, one must read the government program, page 2. Government will foster ethics and integrity as core values in the works of life, page 3. There will be an electoral commission, a commission to be set up to bring reforms in our electoral system. We talk about the right of recalling members of parliament.
Yes.
To enhance transparency in the political sphere, combat corruption, and ensure free and fair election. New legislation will be introduced for funding of political parties. So it's relevant to what I'm saying. What I'm merely saying, Madam Speaker, is my understanding is that this should be considered what I understand when I read the phrase, a government which will foster ethics and integrity as core values. Now, Madam Speaker, let us talk about the same page 3, we're talking about anti-defection provisions. In the same chapter, we talk about consolidation of democracy. Now, Madam Speaker, as you see, I am alone here, the leader of opposition has walked out, rightly so. I would have done the same had I not had to make the speech, and because some are being bullies. Let's not forget, we are two in this parliament, and we have to listen to bullies.
Honourable member.
To a bully, in fact.
If you carry on in this vein, it's not going to help anybody. Don't forget, I have come to this House to uphold the dignity of the House. We know what has happened before. We don't want this to happen again. So I have told you in the past, I will defend the rights of everyone, including the rights of the opposition. And you have seen how I have acted up to now. So don't overdo. Don't put me in a difficult position. That also goes for everybody else.
Yes, Madam Speaker. So I was talking about the anti-defection provisions. I was saying, we are two de malheureux membres de l'opposition.
C'est comme ça.
Hopefully free soon. One might ask themselves. But for now, we are two.
You're provoking.
No, I'm not. Madam Speaker, I am making my speech. Am I not allowed to express my views and comment on the issue?
Don't talk about the independent member.
But why is that? I'm talking about Parliament, Madam Speaker.
He can defend himself.
Okay, fair enough. I won't talk about Mr. Kira. Madam Speaker, anti-defection provisions. As I said, we are two. And as I said, government has expressed intention to consolidate democracy. That is clear from the program, electoral program. That is clear from the government program. But, Madam Speaker, one can only but ponder, why is it that after the election, 60-0, plus 2 MPs from Rodrigue, as is accustomed, 62-4, government did not see a problem. Knowing how the best loser system works, how myself, Mr. Lejonga, and 2 other members have been appointed as best losers for the opposition. I am sure, Madam Speaker, you are well aware of the provisions, the mechanism of the best loser system. So the 4 MPs repêchés sous le système du best loser ont été repêchés pour servir à l'opposition.
Je n'ai jamais... Members, I know this very well. You cannot say that. When you have the best loser system, if you look at the first schedule or second schedule of the Constitution, it doesn't say that you are going to be in the opposition. I think Honourable Béranger has been a best loser in the past. It doesn't say where you're going. You only, let me say, I know the Constitution fairly well. It only says that so-and-so, because il y a un calcul, on va nommer monsieur un tel ou madame un tel, mais on ne dit pas où cette personne doit siéger. J'ai jamais vu ça nulle part.
It follows, Madam Speaker, that if 2 different alliances have faced each other at an election in Rodrigues, that 2 of them must be from the opposition.
I will not... yes.
We have a constitution. We have an electoral commission. We go by the law. He can't be allowed to challenge what has happened. He's out of order.
Of course. Honourable member, you've already gone beyond your time because I'm giving so many rulings.
I understood from the...
I will give you time.
No, but
I will give you a little bit more time. But you cannot raise such issues in this debate.
It is our understanding with the whip that time has not been limited, curtailed, for this debate for the opposition. It's not.
I have.
And time has not been allocated. I am not aware of the time allocated to me.
But don't in any case, okay, I will give you time. You had 10 minutes from the paper that I have. If you had called on me this morning, we would have sorted things out. I will invite you next time to come and see me. And I say that, DPM, please. I am saying to everybody,
Let me move on since I have no time.
no, but let me say to everyone, you're free to come and see me in my office when you don't understand something or you want. You can contact me even by phone. We did talk on the phone today. Okay, I'm giving you some more time, but
So how much time do I have exactly? 10 minutes.
you did have 10 minutes, but you're left with 5 minutes now.
Okay,
I'll
Madam
give you
Speaker,
5 minutes now.
let me move on.
Yes.
We've spoken about, I come back to the
Members.
answers given by the Prime Minister on the last occasion during the Prime Minister's question time regarding the massive scandal that is phone tapping.
Yes.
Right. Now, there is provision in the government program to bring legislation to, of course, to ensure that covert surveillance is carried out strictly and necessarily for the purpose of prevention and crime. However, from the reply given by the Prime Minister, questions arises now as follows with regards to the uncovering of data that is being done. The first question is whether this legislation, which I suspect will come after the exercise of inquiry has reached sufficient stage of uncovering data, I would ask the Prime Minister, I would ask the Prime Minister to come up with a proper safeguard. Either I have asked for the appointment of a commission of inquiry that is to shed light on the whole affair, and he has, I think, understood the point. But the other point, with regard to data that has now been uncovered, which is being retrieved, I am asking the Prime Minister, pending this new legislation, to put it under some sort of judicial oversight, judicial control, so we know, we are sure that data, which, don't forget, is unlawfully obtained anyway, is not subject to, and I'm not saying by the Prime Minister, I'm not saying that. I'm saying by any person who might be the same persons who've done it before. How do we know? So make sure, if you're not prepared, and I think you should go with the Commission of Inquiry, make sure that you put proper standard safeguards, independent safeguards, in place before uncovering the data, which you were confident in your answer, Prime Minister, Honourable Prime Minister, that you would uncover. So that is my plea to you. Secondly, Madam Speaker, I hope that this new legislation will come with this, will be set up and headed by either a former judge of the Supreme Court or a former judge of the Commonwealth as an oversight, so that we ensure...
You don't mean as an oversight. That would mean something else.
Well, as a form of control.
I know what you mean, but it's not the word.
The Commission would have oversight of the actions. It is what I mean, as an oversight of whatever is being done to ensure that it is for covered surveillance in line with the detection of crime and national security. We understand. Perhaps it can't be made through a Parliament committee because of sensitive information, but there has to be some control and oversight. Now, with regards to the appointment of senior officials appointment committee, I've read in their program that it is to be done à la Seychelles. This was not said in the government program, but it is said in the manifesto, à la Seychelloise. It says, recrutement ou nomination des responsables des institutions publiques importantes par constitutional and other appointment authority à la Seychelloise. And, Madam Speaker, do you know how it's done in Seychelles? The CEA, Constitutional Appointment Authority. First of all, the composition is key. Appointment. That was my point to the Honourable Attorney General earlier as well. The appointment is key. And how is the appointment made? There's a president of an executive with executive powers. He appoints out of 5 members of the Commission, he appoints 2. The leader of opposition appoints 2. And the 4 members agree on the appointment of the chairperson, the 5th member. Any subsequent filling of seats is done in the same manner. Now, the appointments to be made, Chief Justice, they're the great Auditor General, similar to the Director of Audit, and Attorney General, etc., other important constitutional appointments are done in a transparent manner. There is a call for candidacy. Then it does, of course, it will go through the applications. And then, once it has deliberated, it will make recommendations to the President. And for the President to not act on the deliberations, he would have to have a reason, a valuable one. And if there's more than one recommendation, then notes are given to the President, saying that this choice is better or this choice. So, Madam Speaker, the question is this senior official appointment committee à la Seychelloise? Because this is what is done in Seychelles. This is the crux of it.
Don't repeat yourself.
Is this...
Time is almost up.
Is this committee going to be done? Do we mean à la Seychelloise in that we're going to have parity of members appointed by the executive and by the leader of opposition? Is this what we mean? Or is it merely a commission that recommends? How is it going to recommend? How is it going to invite for candidacy? All of this, I hope, will be explained by members of the Alliance. But, Madam Speaker, the leader of the opposition is not here. He's not speaking.
No, but you can't take his time.
And we have 2 members of opposition. And I've had to deal with this for half of the speech. So I would ask you some additional time. Otherwise, you should have stopped them, Madam Speaker.
I gave you 5 more minutes. I'm giving you 1 minute to round up.
Well, Madam Speaker, there's a lot to say.
There was no need for you to explain the Seychelles method.
There is, Madam Speaker. Because that is important, because it is said black on white. It is a promise. I am merely seeking explanation as to why à la Seychelloise has not been referred to. I can go on. The case of, for example, provisional charges.
You're not rounding up.
I will round up.
Because you know how many issues one can raise regarding that program.
I will round up with provisional charges. Is not part of the program.
Okay.
And I hope, because we've seen the abuse of provisional charges.
So you're making a proposal.
I think there is consensus. I think there's consensus on the abuse of the system and the practice of provisional charges.
That's what I've gathered.
I call upon the Attorney General. And I must say, Madam Speaker, I can't just criticize. I must say that the Attorney General is doing a remarkable job in the program with regards to the legislation that he's bringing. I will say the same for the Minister of Education. I think he's done a remarkable job as well. But for the rest, Madam, for the rest, Madam Speaker, I will simply say the proof will be of the pudding will be in the eating. If I can conclude, Madam Speaker, I will conclude on only one thing. According to the Moody's latest report, and if we believe Mr. Sushil Kushiram, who's a respected
don't bring foreigners in the debate,
economist, if we believe their
analysis,
but
don't bring him there.
Fiscal consolidation, which is being expected from this government, means increasing revenue, that is taxes, and decreasing spending. I will finish by saying half of this program provides for increased spending on social benefits, which, according to Mr. Kushiram, is the obvious.
Mr. Kushiram is not here. No, somebody else did that also on the other side. We cannot bring strangers.
I will table if you want his thing.
You're making a speech. You're making a speech.
But I am making a speech.
Don't table anything. It's not time for tabling. You're supposed to round
Right.
up.
I am rounding up by saying Moody's expects government, whether they form that expectation on their own or through consultation, expects government to increase revenue, that is taxes, and decrease spending. And it will thus be very difficult for any government, not just this one, to execute the program on which they have been elected. So, Madam Speaker, that is the conclusion. The conclusion is that...
Wait for the pudding to be ready. Wait for the pudding to be ready.
The conclusion is, Madam Speaker...
I've read
yes, I'm coming to the conclusion. The conclusion... Madam Speaker, if I'm being interrupted like this...
You've said 3 times that you're concluding.
But I have to repeat myself. I cannot even hear myself finish with the remarks. You are not putting order. I'm sorry to say, Madam Speaker.
It's difficult because the time... You know why? Because it's the difficult time of the night. Everybody clearly... You know what happens when people are hungry, you know?
Let me simply say, you know, if I get, Madam Speaker, if I get interrupted 10 times, I have to repeat myself 10 times. Because every time I start a sentence, someone behind me is making comments, in front of me they're making comments. If they will allow me to conclude, Madam Speaker, I will.
I've allowed you 3 times already.
No, not you, Madam Speaker. Those around. Those who do not want to listen to that one opposition MP making his speech. So, Madam Speaker, my conclusion
Please
is...
keep quiet so that we will be able to listen to that conclusion.
I've trimmed down my speech by 95%. I will come to the most important, the conclusion. In light of Moody's expectations that they have formed. And in fact, in light of what experts are saying, that this should not wait the budget. This should come now.
Okay.
And in light of the fact that Statistics Mauritius, that the financial secretary, who, according to the State of the Economy report, have played a role in falsifying figures, and these experts are saying have to be taken to task, then what I will ask the Honourable Minister of Finance, the Prime Minister, is that... I have been to the Prime Speaker. But I can't, I'm sorry.
Je vais lever la séance si ça continue.
Laissez-le terminer. But then, should I just talk in this noise and then that's it?
No, but
is it just the point of talking?
You're taking time to finish your sentence.
Because I'm getting interrupted, Madam Speaker. I am trying to make a speech, I'm getting interrupted at every word I say. Look, if it's like that, I'll sit down.
Yes.
The Prime Minister will answer.
Okay, members, I know it's difficult.
It's difficult to listen to the opposition.
It's difficult. Honourable member. Ah là, ça va pas là, hein? Honourable members. Okay. Now, stop it. Stop it, members. Stop it. We are not going, I am not going to tolerate this anymore. Let us all raise, I'm raising now, we're going to break. We're going to break for dinner for 1 hour. 1 hour? Yes, we need 1 hour to get back to our senses. And okay. Oh la la.